Welcome to The Explainer. Today, we're unpacking a massive legal trap that is unfortunately catching a lot of non-resident Indians totally off guard when they try to invest in real estate back home.
Picture this, a beautiful, serene farmhouse surrounded by lush green fields. It's the ultimate NRI dream investment, right?
Well, absolutely wrong. Under FEMA, buying agricultural land is strictly prohibited for NRIs. If you go through with it, the purchase is legally void, like it never happened. And the penalty? A massive 3 times the transaction value.
So the developer tells you it's perfectly fine, right? Their glossy brochure calls it a luxury resort villa. But here's the catch. If the 712 extract says agricultural land, you're stepping straight into a massive gray area where marketing fiction meets harsh legal reality.
Now, what can you buy? As an NRI, you're completely free to invest in residential properties, commercial spaces, and built-up non-agricultural real estate with zero RBI approval needed. But when it comes to agricultural land, your absolutely only legal exception is inheriting it from a resident relative. So bottom line, always verify the state land records, like the 712 extract, to confirm the true legal status before you even think about signing an agreement. By the way, to make navigating all this super easy for you, just DM me the word land and I'll send you a free NRI property due diligence checklist. It's an absolutely vital tool to keep your hard-earned capital safe.
Okay, let's dive into Section 1, the resort villa trap, marketing versus reality.
You see, brokers love to dress up agricultural land. They'll throw up a boundary wall, dig a nice swimming pool, put in some fancy security gates, and suddenly call it an eco-resort. It's a classic bait and switch to make you think standard agricultural rules just don't apply. But here is the hard legal truth. The physical structure, literally irrelevant. What actually matters is the official state land revenue record. Depending on the state you're buying in, this master zoning document goes by different names. The Kasra up north, the RTC or Pahani in Karnataka, or the 712 extract down in Maharashtra. This piece of paper strictly determines the land's classification. If it says agricultural, it's agricultural. End of story. That official state paper trail entirely supersedes whatever glossy brochure the developer handed you.
It's wild when you contrast how a property looks to the naked eye versus how the law actually sees it. On one side, you're looking at a stunning luxury house, manicured gardens, the whole shebang. It looks like the perfect residential vacation home. But legally, if that master zoning record hasn't gone through a formal, finalized change of land use and it still says agricultural asset, then under Indian law, you are buying a farmhouse on restricted agricultural land. You absolutely cannot rely on some incomplete or disputed conversion.
Now, what's really interesting about this next part, let's move to Section 2, FEMA's strict legal reality and the true cost of noncompliance.
Because the laws governing this, they are entirely unforgiving. We're talking about the Foreign Exchange Management Act, or FEMA, of 1999. This isn't just some casual administrative guideline that your bank or a friendly seller can wave away with a wink and a nod. No, this is a strict statutory restriction enforced by the Reserve Bank of India to protect agricultural resources from speculative foreign capital. Under these rules, there are 3 very specific categories of real estate that NRIs, overseas citizens of India and persons of Indian origin, are explicitly barred from purchasing. Number 1, agricultural land of any description. Number 2, plantation property, so that's your tea, coffee, rubber, and timber estates. And number 3, farmhouses. You can't buy them directly, you can't buy them indirectly through a local power of attorney, and no, you can't just set up a domestic corporate shell to bypass it. The prohibition is absolute.
And if you cross this line, the financial hit is staggering. Under Section 13 of FEMA, the monetary penalty for an illegal purchase can hit up to 3 times the transaction value, or 2 lakh rupees, whichever is higher. So just put that into perspective. Imagine pouring your life savings into a property only to be slapped with a fine triple what you originally paid for it. No way.
And the nightmare actually doesn't stop at the fine. If the Enforcement Directorate catches you holding this illegal agricultural land, their actions are brutal. Step 1, your entire transaction is deemed legally void right from the jump, meaning you never actually held valid legal title to the land. Step 2, the property can be outright confiscated by the government, just gone. And Step 3, the RBI can force a divestment. They'll literally direct you to sell the land to an eligible resident Indian, usually under incredibly strict timelines and at market value, while you're racking up daily penalties. And let me tell you, playing the I didn't know card, or claiming your broker said it was fine, that is not a valid legal defense.
So the crucial point is, let's check out Section 3, the inheritance exception, basically the legal loophole.
You're probably wondering, is there any legal way an NRI can acquire this type of land? Actually, yes. FEMA explicitly allows NRIs and OCIs to inherit agricultural land, plantation property, or farmhouses from a person resident in India. Whether that happens through a formally registered will or even if there is no will at all through intestate succession, the law completely recognizes and protects your right to inherit ancestral farmland from your family members. So you don't need to panic and immediately sell off your grandfather's farm just because you moved abroad.
However, holding on to that inherited farmland, it does come with a very strict set of compliance rules. First off, you absolutely must update the local mutation records at the Revenue Office to reflect you as the new legal owner. Once that's done, you're free to hold the land and farm it legally. And honestly, the brilliant news here is that India levies zero inheritance tax when you receive it. Plus, agricultural income from that land is totally exempt from central income tax. But, and listen, this is absolutely crucial, if you ever decide to sell that inherited farmland, you can only sell it to a resident Indian citizen. You cannot transfer it to another NRI or OCI. And just a quick reminder, repatriating those sale proceeds outside of India is subject to that strict $1 million annual cap through your NRO account.
Let's move to and see how this builds into Section 4, Safe NRI Property Investments, and where you should actually put your capital.
Look, while agricultural land is a regulatory minefield, the broader Indian real estate market is incredibly welcoming to your capital. Under FEMA's General Permission Framework, you are completely free to buy residential properties. We're talking apartments, flats, independent houses, villas, you name it. You can also go heavy into commercial properties. Think office spaces, retail showrooms, warehouses, and industrial sheds. You can even snap up fully converted non-agricultural or NA plots meant for housing construction. For all of these categories, you don't need any prior RBI approval whatsoever, provided your funds are routed properly through authorized banking channels like your NRE or NRO accounts.
And I want you to really soak in this quote, pulled directly from the regulations. There is no statutory limit on the number of residential or commercial properties a non-resident can acquire. That's a huge deal. It means your investment potential in these approved sectors is literally unlimited. You could build a massive, diversified portfolio, say apartments in Mumbai and commercial spaces in Bengaluru, without ever running afoul of the Reserve Bank of India. The government actively wants your investment in these urban and commercial development sectors.
And this brilliantly illustrates our final section, Section 5, the ultimate land check and protecting your investment. So how do you actually protect yourself before transferring a single rupee to a developer's bank account? It all comes down to a few strict documentary checks that you, as an NRI, must demand to see. Step 1. Obtain the official state revenue record yourself. Whether that's the RTC, the Pahani, the Khazra, or the 7/12 extract, get it yourself. Do not just trust some blurry photocopy the seller hands you, verify it directly through the state's digital portals. Step 2. Officially confirm the non-agricultural or NA status on that specific document. And step 3, if it's a developed plot on the outskirts of a city, you need to check for the formal, finalized change of land use, or CLU, order from the government. If that conversion application is merely pending, or if it hasn't been formally granted yet, walk away. Don't risk it. So I'll leave you with this final thought to really reflect on for your own due diligence strategy. When you're gearing up to make your next major property investment back home in India, ask yourself, are you relying on a developer's glossy brochure or the official state revenue record? Choose wisely, always do your homework, and keep your investments safe and legal. Thank you so much for joining me on this explainer, and I will catch you in the next one.